Welcome back to the video lecture on East Asian States Leadership International Law. This time, again, we're talking about the best solution for the forced labor compensation issues, emphasizing the need for careful procedural consideration. Currently, Korea and Japan are in a process of finding a solution to the issues of the compensating the forced labor victims who were victimized during the Japanese colonial rule. Among other factors, the two countries have taken into consideration the perspectives of the victims and implementation of the Supreme Court decisions and Japan's sincerity in addressing the issues in order to come up with a final agreement. As the Korean Ministry of Foreign Affairs reviews the compensation victims of the forced labor through the Foundation for Victims of the Forced Mobilization by Imperial Japan, in response to the Supreme Court decision recognizing the responsibility of Japanese companies to compensate for forced labor during the colonial period, the differing positions of the parties involved are becoming very evident. Whereas the victims are steadfast in their stance that the dependent Japanese companies must provide the funding and the Japanese governments and companies must apologize, so is Japan's firm in its stance that the forced labor issue was resolved through the 1965 Claims Agreement. According to Japan, the Korean Supreme Court ruling ordering Japanese companies to provide compensation and apology to the victims of forced labor is a violation of international law and thus unacceptable. The Japanese government also recently stated that even if the Japanese companies donate to the foundation, it does not constitute as an acceptance of the court's ruling as long as the foundation has retracted its right to indemnification, the seeking reimbursement from the Japanese companies. The problem with the current resolution process as undertaken by the Ministry of the Foreign Affairs is not so much about basic direction, but rather the procedural steps need to reconcile the opposing views of the parties involved. The solution to the forced labor lawsuit relates to the Claims Agreement, which settled the legal aspect of the Japanese colonization, rise in the guarantees of subrogation, the exercise of right to indemnity, and the securing of the historical and moral advantage. The first, the Korean government must sincerely apologize to the victims of the crime against humanity during the Japanese colonial era for failing to adequately address the problem during the process of the normalizations of the diplomatic relations with Japan and concluding the Claims Agreement. After all, further clarity regarding Korea's position on its internal issues is very crucial. The second, the Korean government must take measures to provide compensation in advance to such victims through legislative acts such as subrogation, the exercise of rights to indemnification, and enactment of the special rights. And third, the victims should be treated with respect, and their sufferings should be shaped and shared by the national and international community as a historical lesson from a post-colonial perspective. This should be done through the development and implementation of domestic and international policies that focus on inclusiveness rather than the aggregation of adversarial relations between the parties involved. Ultimately, the solution lies internally rather than between Korea and Japan. The careful re-examination should be made to ensure that no procedural step, namely the sequence of the events, is overlooked, since it would be impossible for either Korea or Japan to publicize the issue of compensation for victims of forced labor during colonial era from the initial standpoint. The question of whether international provide the basis for the compensation to victims of colonization who were suffered in the hands of oppressive imperialistic powers has mostly arisen long after most of the territories in question gained independence. The expansion and development of norms such as human rights, environment, injustice in modern international law, which is based on state sovereignty and non-interference in domestic affairs, are expected to contribute positively to the ongoing process of decolonization. When reflecting on the issues between Korea and Japan, whose relations was limited that of colonized and imperial power, taking into consideration current international trends, Japan's recognition of its past deed is the missing piece for the successful resolution of the ongoing conflict between two countries. It is with great hope that Japan can become a leading country in international law by demonstrating normative legitimacy beyond legalism through state practice. No compromise can be made between the illegality and legality of Japan's colonial rule asserted by both Korea and Japan respectively. Despite the inability of the two sides to agree on the legality of Japan's colonial rule, the Treaty on Basic Relations between Japan and Korea was nevertheless established in 1965. In other words, Korea and Japan's conflicting the perceptions of Japan's colonial rule inherent in the Treaty on Basic Relations between Japan must be acknowledged as a fact. Despite the legal controversies in Korea, the so-called third-party abnegation method, whereby Korea's the foundation for victims of the post-mobilization by Imperial Japan, will compensate the Japanese colonial era for victims of the basis of the 2018 Supreme Court judgment. Granting such victims the compensation is a measure to tie up long-standing diplomatic issues between Korea and Japan. Japan's response, which includes the related company's contribution to the compensation fund and a formal apology from Japan, are recognized very essential elements for all diplomatic resolution. If such measures are adopted by Japan, Korean government will have no justification to persuade the victims of forced labor to consent to the proposal. The outcome of the diplomatic negotiation between Korea and Japan is difficult for anyone to predict, as their efforts are showing the signs of a standstill. This pending issue only resurfaced when Japan's government announced its plan to discharge of the radioactivities contaminated water stored in the Fukushima nuclear power plant in April 2021. After Japan's scheduled discharge of the contaminated waters into the Pacific Ocean in April of the last year, the diplomatic issues surrounding relations between Korea and Japan will no doubt escalate depending on the Korean government's response to discharge. If the Korean government decides against taking any proactive measure in compensation of the relations between Korea and Japan, it will be considered as a dereliction of a duty on an issue that poses a great threat to the public safety. At the same time, the appropriateness of the public calling for countermeasures, such as international litigation, that could lead to the collapse of the Korea-Japan's resolution and relations is very unclear. If the discharge of contaminated water occurs before the forced labor issues is resolved, and Korea initiates legal proceedings by raising international legal issues, any diplomatic bargaining power against Japan will be lost. Under such circumstances, there is a high probability that the forced labor issue will regress in its original state, since Japan believed that the forced labor victims' claims were legally and completely extinguished by the 1965 Claims Agreement. Conversely, if the discharge of the Fukushima contaminated water and Korea's international legal action against such discharge occur after issues of the forced labor is resolved diplomatically, Japan is believing that they made sufficient concessions regarding the issue of forced labor, will object, and Korea-Japan's relationship will turn hostile. Ultimately, regardless of the situation, Korea's diplomatic power will be put to the test by the simultaneous development of the distinct issues of the forced labor, which is undergoing the final stage of negotiations, and the discharge of radioactive water from Fukushima. It is very unclear what position of the Korean government is aiming for regarding the discharge of contaminated water from Fukushima. However, among the most important interested parties to the issue, Korea is giving the impression of a somewhat lukewarm response. Korea can initiate an arbitral proceedings claiming that Japan's discharge of the contaminated water violates the international law, while also applying for provisional measure. For the International Tribunal of the Italos to decide on an interim measure, the jurisprudence of the arbitral tribunal that must be presumed to exist, and there must be urgent risk and serious threat of the harm to the right of the complainant states, for example, Korea. When deciding on the various measures the Korean government can take after discharge, it is very essential to collect scientific evidence that can propose the urgency of the risk and seriousness of the harm by this discharge. For the formulation of the future government response, the accurate assessment of the reality and policy alternatives are both necessary. Thank you very much for your very kind attention.